All right, our first panel today is on Stare Decisis, to stand by things decided. We were all taught in law school that this principle provides consistency and stability in case law, until it doesn't. Should stare decisis always control? What are the circumstances when it should not? How has it impacted current case law and recent opinions federally and at the state level, especially here in Kentucky, with its unique regulatory regime? We're very fortunate to have with us today a very distinguished panel to discuss this topic and a much esteemed moderator to navigate the issues associated with this legal principle. Our panel includes Professor Michael Morley, Assistant Professor at Florida State University College of Law. Professor Morley teaches and writes in the areas of election law, constitutional law, remedies, and the federal courts. Before joining FSU Law, Professor Morley was a Clemenco Fellow and lecturer on law at Harvard Law School. Prior to entering academia, Professor Morley served as Special Assistant to the General Counsel of the Army. He also worked as an associate at Williams & Connolly and in the Supreme Court and Appellate Group of Winston & Strawn, LLP. Sorry. Both in Washington, D.C. He clerked for Judge Gerald B. Joflad of the U.S. Court of Appeals for the 11th Circuit. Professor Morley earned his J.D. from Yale Law School and received his undergraduate degree from Princeton University's Woodrow Wilson School of Public and International Affairs. His work has been quoted by the U.S. Supreme Court, and he was counsel of record in the Supreme Court for the successful petitioner in the landmark First Amendment case, McCutcheon versus FEC. Then we have the Honorable Laurance VanMeter of the Kentucky Supreme Court. Justice VanMeter was elected to the Kentucky Supreme Court in 2016 from the 5th Appellate District. Upon taking office in 2017, he became just the third justice to have served on all 4 levels of Kentucky's unified court system. Prior to be elected to the Supreme Court, Justice VanMeter served 13 years as a judge of the Kentucky Court of Appeals. He currently serves as chairman of the Kentucky Evidence Rules Review Commission, as co-chair of the Supreme Court Civil Rules Committee, and is the Supreme Court's liaison to the Kentucky Bar Association's Continuing Legal Education Commission. Before becoming a member of the judiciary, Justice VanMeter practiced law in the Lexington firm of Stoll, Keenon, and Park. He received his undergraduate degree from Vanderbilt University and his J.D. from the University of Kentucky College of Law. And he's currently a candidate for an LLM degree from the Duke University School of Law. Then we have John Scheller of the firm Stoll, Keenon, Ogden. Mr. Scheller is a member in Stoll, Keenon, Ogden's Louisville office and has been with the firm since 2007. He has practiced labor and employment law for many years, including some notable cases establishing significant legal precedents. He also serves as chair of the Kentucky State Labor Relations Board. He received his undergraduate degree from Ball State University and his J.D. from Indiana University. And finally, Cassie Chambers Armstrong, currently an attorney with Kaplan, Johnson, Abate, and Byrd. Ms. Armstrong is vice chair of the Kentucky Democratic Party. She also clerked for Judge Thapar when he was on the district court, and her significant litigation experience has included work on class actions, appeals, and other complex litigation. And previously, she was a Skadden Fellow at a Kentucky nonprofit where she formulated and implemented impact litigation strategies. Ms. Armstrong graduated from Harvard Law School. Prior to attending Harvard, she earned a master's degree in public management and governance from the London School of Economics. She also has a master's degree in public health from the Yale School of Public Health, and she earned her bachelor's degree from Yale. She has worked in a number of healthcare environments, including the U.S. Senate, the Connecticut State Legislature, the UK Parliament, and the American Public Health Association. And importantly, finally, we are fortunate to have with us the Honorable Amul Thapar to moderate this panel. Judge Thapar sits on the United States Court of Appeals for the 6th Circuit. He is a former United States District Judge for the United States District Court of the Eastern District of Kentucky and former United States Attorney for the Eastern District of Kentucky. Judge Thapar has also worked for the law firms of Williams & Connolly in Washington, D.C., Squire, Sanders, and Dempsey in Cincinnati, and served as an assistant U.S. attorney in both the Southern District of Ohio and the District of Columbia. Prior to that, Judge Thapar served as a law clerk to the Honorable S. Arthur Spiegel, who sat on the United States District Court for the Southern District of Ohio, and the Honorable Nathan R. Jones, who sat on the U.S. Court of Appeals for the 6th Circuit. Judge Thapar received his undergraduate degree from Boston College and his law degree from the University of California at Berkeley. Thank you all for agreeing to participate on our panel on Stare Decisis, and we look forward to your thoughts and discussion. Thank you.
Good morning, everyone. First, on behalf of all of us, we want to thank the Federalist Society and the state chapter for having us discuss this important topic. I will serve as the moderator, as you just heard, and in that role, I will make sure that your questions are actually questions so we can cut to the chase and hear from the panel that they brought here to speak. So before I'm rude to you, I just want to warn you as to why I'm being rude. And we will start with Professor Morley, who's going to give us an overview of the entire topic in his short time that he has.
Great. Thank you very much, Your Honor, and I'd like to thank the Federalist Society as well as the Kentucky House of Representatives for holding this event. I haven't given a speech in a state legislative chamber since Model Youth in Government back in high school, a joke that perhaps only a crowd of lawyers would appreciate. Many debates over constitutional interpretation are what we can think of as first-order questions of interpretation. Should we apply originalism, looking for the original public meaning of the Constitution's text? Spoiler alert, yes, that's exactly what we should be doing. Or instead, should we adopt a living constitution theory, reinterpreting the meaning of the document in light of evolving social norms and values? And Justice Scalia teaches us, of course, that living constitutionalism is antithetical in many ways to the entire project of constitutionalism, which is to hold constant certain values and to remove them from the realm of democratic debate. And in fact, reinterpreting the Constitution to recognize new rights reduces the flexibility of future legislatures to be able to respond to social change. But today I want to focus on a different question, a second-order question. Assuming that you are persuaded by originalism, what is the proper relationship between an originalist theory of constitutional or statutory interpretation and the doctrine of stare decisis? Stare decisis, as all of you know, roughly translated, means to stand by decided matters or to let the decision stand. And it's the notion that a court will follow precedent in most circumstances rather than applying its own understanding of the best meaning of the law. There are two types of stare decisis. Vertical stare decisis, which is the notion that lower courts within a judicial hierarchy must follow the rulings of higher courts, and this can become complicated when you're dealing with unusual appellate structures, such as three-judge district courts, where their rulings aren't appealable to circuit courts of appeal, they're directly appealable to the US Supreme Court. We get difficult questions of vertical stare decisis in terms of whether they're bound by Court of Appeals precedent. But today I'm going to focus primarily on the other type of stare decisis, horizontal stare decisis, the notion that a court will follow the earlier precedents of that same level of court. So we see this at the Court of Appeals in what most circuits refer to as the prior panel rule, that a three-judge panel of a Court of Appeals is generally bound to follow the rulings of earlier panels, and if they disagree, those earlier rulings can only be reversed by the court sitting en banc. Of course, at the Supreme Court, we also face questions of stare decisis in terms of whether the court will choose to abide by and implement its earlier precedents, or instead whether it will overturn those precedents. And horizontal stare decisis poses the biggest issues for the Supreme Court precisely because there isn't another policing mechanism. If a Court of Appeals panel strays too far from prior circuit precedent, that court sitting en banc can grant rehearing and enforce compliance with the law of the circuit, whereas with the Supreme Court, once it rules, there is no further layer of review to ensure that it abides by earlier precedent. I want to emphasize, stare decisis is at its core a theory of judicial error. Under what circumstances will or must a court enter a judgment or take some other action on grounds that it believes to be substantively erroneous simply because that is what precedent demands? The great legal scholar Tyrion Lannister reminds us, we make peace with our enemies, not our friends. The same is true here. A justice or judge doesn't need a theory of stare decisis to tell him or her to follow opinions they agree with. You need a theory of stare decisis when you think the previous precedent is wrong. So why would we have such a doctrine? Why would we have a notion that courts must follow demonstrably erroneous precedent? The Supreme Court's ruling in Payne versus Tennessee points to 4 main reasons, and I'll add one more. The first is predictability, that litigants, attorneys must be able to look to precedent to determine what the law is in order to be able to advise their clients as to what governmental decision makers are likely to do. Secondly, there's the notion of consistency, that if courts abide by prior precedents, this ensures that their decisions are being cabined or guided by neutral principles rather than being twisted or stretched to apply differently to favored litigants. Third, of course, there's reliance. Actors in the private realm rely on precedent to tell them what the law is, to guide their actions, to guide their investments. And so you would have serious due process issues with essentially ripping the carpet out from under them and changing the law at the end of the case, right? The last thing you want to hear from the court is surprise. Fourth, there's the perceived integrity of judicial process. The notion that if the law is supposed to be able to reliably govern human conduct, courts can't treat it as a pure matter of politics that they change simply because they disagree with it. And to this, I will add a fifth consideration of judicial economy, that judges simply aren't in a position to be able to relitigate every single issue from scratch, that there has to be a notion of precedent in order to limit, to cabin the scope of disputes before them, to be able to help litigants and the court identify which matters truly are open for judicial debate. The Supreme Court tells us that stare decisis applies with greater force in statutory cases where Congress is free to overturn the Supreme Court's interpretation if it disagrees with the court's reading of the statute, and stare decisis accordingly applies with lesser force in constitutional cases where the Supreme Court is the last word on the issue, short of a formal constitutional amendment. The Supreme Court tells us in its recent ruling in Janus that it will apply stare decisis unless there are, quote, strong grounds for not doing so, a subjective and indeterminate legal standard. It did identify 5 factors that it takes into account in determining whether such strong grounds exist. These include the quality of an earlier court's reasoning, the workability of the rule the earlier court adopted, whether the ruling at issue is consistent with other rulings, whether there have been subsequent developments that undermine the reasoning of the original opinion or that undermine perhaps some of the legislative facts upon which the original opinion was based. And finally, we return to the notion of reliance. Has there been substantial reliance by private actors, by society on the ruling? How disruptive would it change in precedent be? All of these considerations are primarily consequentialist type considerations. They mean that originalist judges committed to enforcing the original public meaning of the Constitution may wind up having to apply and enforce non-originalist interpretations of the document. So this leaves us with the question, is that okay? I'm not here to sell you on a particular answer, but I will outline 4 major answers that jurists and commentators have suggested. The first is the approach presented by Justice Clarence Thomas, and I would suggest that Professor Gary Lawson could also fairly be put into this category. And that's the notion that stare decisis is not an excuse for following non-originalist rulings or even erroneous originalist interpretations. Under this view, the Supremacy Clause tells us the Constitution is the law, not Supreme Court rulings, not Supreme Court interpretations of the law, and for a court to follow an erroneous interpretation, a non-originalist interpretation of the Constitution, is tantamount to amending that document outside the context of Article 5. So under Justice Thomas's approach, the answer would be you should virtually never apply stare decisis as a grounds for ignoring or rejecting the correct originalist interpretation of the document. A second approach is offered by Professor Randi Cosel, who says that stare decisis may be a legitimate fallback tool to use, where evidence of the Constitution, the meaning of the Constitution's text, where evidence of original public meaning is in some conflict, where you can't confidently come to a single correct originalist interpretation of the Constitution. In such realms of indeterminacy, Professor Cosel suggests that stare decisis may be a second-order fallback. So once you've left the realm of interpreting the document and you are now in what they call the construction zone, stare decisis is an appropriate policy-related consideration to guide courts' interpretation where indeterminacy exists with original meaning. A third approach is suggested by Professors John McGinnis and Michael Rapaport. They argue that, this is sort of a meta-argument, they argue that an originalist conception of Article 3 itself requires courts to apply stare decisis, or at least authorizes courts to do so. That the original understanding of the judicial power included notions of stare decisis that English common law courts traditionally applied, and so for courts to faithfully execute that judicial power, for courts to faithfully execute the judicial function under an originalist interpretation of Article 3, that authorizes them to apply stare decisis even when a first-order originalist interpretation of other constitutional provisions might lead to a different outcome. And they point to several circumstances where courts should give special consideration, should be especially willing to apply stare decisis rather than a first-order originalist interpretation, where stare decisis would help the court avoid imposing large costs on litigants or society, where an opinion has become part of our social fabric, part of our social structure, where undoing an opinion would lead to wide-scale changes, and finally, where the original constitutional process itself excluded certain members of society. So, of course, they point to the exclusion of African Americans during the founding era. Recognizing a non-originalist approach, using stare decisis to adopt a non-originalist approach, they argue would be an appropriate response. And finally, Professor Henry Monahan offers a fourth approach to reconciling stare decisis with originalism, and he suggests there simply comes a point in time when precedents become so firmly established, so integrated into our legal firmament, that we can think of them as transformative, that in a sense, a judicially created constitutional moment where he suggests that certain precedents, perhaps such as Miranda, can be regarded as the effective equivalent of constitutional amendments, and so it is simply impossible to go back to a pure originalist interpretation. I'm not suggesting any one of these interpretations or one of these approaches is necessarily the best or more accurate than the others, but they at least lay out the field, they at least lay out the framework of different possible ways that courts can attempt to reconcile these two compelling competing values. Thank you.
Thank you, Professor. Justice VanMeter will now talk about the state court decisions and when they have departed and when they are consistent with stare decisis in the state courts, or at least the Kentucky Supreme Court's vision of stare decisis.
Exactly. So I first want to give acknowledgement to my colleague Debbie Lambert and to my former colleague Glenn Acree, who are both here today. I also note the last time I spoke to a Federalist Society group, it was Washington and Lee Law, and I also had a full audience there. I think the fried chicken had something to do with that, though. So. I submitted some articles to Sarah, and hopefully they'll be in the materials that you all have coming out of this. The first is an article from the Wall Street Journal that highlights a difference in the U.S. Supreme Court between Justice Breyer on the one hand and Justice Stevens and Ginsburg on the other hand. And the law professors will tell us that, basically these three tend to vote together, and so it was interesting to me that you have three justices that arguably selected by the president of the same party, that I guess not Justice Stevens, but so they're disagreeing. So the first case that I would highlight, and it's a U.S. Supreme Court, not Kentucky Supreme Court, but these quotations flow through our decisions as well. It's from the John R. Sand and Gravel versus U.S. And so the first quotation is from Justice Breyer, who states, "Our re-examination of well-settled precedent could nevertheless prove harmful. Justice Brandeis once observed that in most matters it is more important that the applicable rule of law be settled than it be settled right. To overturn a decision settling one such matter simply because we might believe that decision is no longer, quote, right, unquote, would inevitably reflect a willingness to reconsider others, and that willingness could itself threaten to substitute disruption, confusion, uncertainty, for necessary legal stability. We have not found any of the factors that might overcome these considerations." Justice Stevens, dissenting, he wrote, "If there's any ambiguity in our cases, it ought to be resolved in favor of clarifying the law rather than preserving an anachronism whose doctrinal underpinnings were discarded years ago." And then he quotes Holmes, and Holmes, this is a pretty famous quote from Justice Holmes. It is revolting to have no better reason for a rule of law than it was laid down in the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since, and the rule simply persists from blind imitation of the past. Justice Ginsburg, dissenting in the same case, states, "Stare decisis is important but not an inflexible doctrine in our law. Stare decisis is not a universal and inexorable command. The policies underlying the doctrine, stability and predictability, are at their strongest when the court is asked to change its mind, though nothing else of significance has changed." And she cites a law review article that I've also included by Justice Powell called Stare Decisis and Judicial Restraint. It's in the Washington and Lee Law Review, 1990. Justice Ginsburg further states, "I surely do not suggest that overruling is routinely in order whenever a majority disagrees with a past decision, and I acknowledge that considerations of stare decisis have special force in the area of statutory interpretation." So, as an aside, you'll notice these themes continue, as Professor Morley pointed out, these themes continue to crop up in these decisions. So back to Justice Ginsburg. Stare decisis has added force when the legislature and the public sphere and its citizens in the private realm have acted in reliance on a previous decision. For in this instance, overruling the decision would dislodge settled rights and expectations or require an extensive legislative response. After today's decision, one will need a crystal ball to predict when this court will reject and when it will cling to prior decisions interpreting legislative text. I'll note, as an aside, that I read this morning in the discussion about this, that this spring, Justice Breyer, notice he was in the majority in that John R. Sand and Gravel case. He says, "Today's decision can only cause one to wonder which cases the court will overrule next." So, depending on the justice, depending on the case, it depends. So the next is a quotation from South Carolina versus Gathers. And this is the quotation. "I agree with Justice Douglas. A judge looking at a constitutional decision may have compulsions to revere past history and accept what was once written, but he remembers above all else that it is the Constitution he swore to support and defend, not the gloss which his predecessors may have put on it." And he quotes a law review article by Justice Douglas called Stare Decisis in the Columbia Law Review from 1949. And I have included in my materials that I submitted both the law review by Justice Powell and this law review by Justice Douglas. So the quotation from South Carolina goes on. "Or, as the court itself has said, when convinced of former error, this court has never felt constrained to follow precedent. In constitutional questions where correction depends upon amendment and not upon legislative action, this court throughout its history has freely exercised its power to re-examine the basis of its constitutional decisions." So is there anybody have a guess who agrees with Justice Douglas? Justice Scalia. That was Justice Scalia. So I don't know about you. I never thought I would read that Justice Douglas and Justice Scalia had agreed. So the reason I included the law review article from Justice Powell is because a lot of the decisions a lot of the reasons he gives for stare decisis are a lot of what Professor Morley just stated. So I won't go through that. So I will talk about the Kentucky Supreme Court now. And personally, I agree with what Justice Powell wrote, as well as Justice Scalia, Justice Douglas, Justice Ginsburg, Justice Stevens, and Justice Breyer. So my background is transactional law, business organizations, and planning. In order to help our clients, we had to have confidence that other lawyers and, God forbid, judges would agree with our interpretations of statute and case law. I tend, I think, to follow what I can see, what I can read. The most obvious one in recent memory, and I'm sure some of you have some other cases that you might think about, but it was a case in which the Commonwealth had appealed a judgment of acquittal in a criminal case after the trial court granted a criminal defendant's motion for a directed verdict. The Kentucky Constitution states that the Commonwealth may not appeal a judgment of acquittal. They can ask for a clarification of the law, but they cannot appeal the judgment of acquittal. So in the case, the trial court had issued a judgment of acquittal, and in response to a motion for directed verdict, it was a close case, I think. But again, he issued a judgment of acquittal, and so the question was whether or not do we follow the Constitution or do we follow a case that had been issued, I think probably about 30 years before, saying that, well, it's double jeopardy, it doesn't really apply, so yeah, Commonwealth can appeal a judgment of acquittal. But what we did, and it was a 7-0 decision, is we relied on the text of the Constitution. So, I'm not going to call out Justice Lambert because actually we looked at, she has not written an opinion in the year that she's been on the Supreme Court that mentions the word stare decisis. So she's off the hook. But I will say one of my colleagues wrote the following. It is often cited that the doctrine of stare decisis did not commit us to the sanctification of ancient fallacy, citing Hillen versus Hayes, which was the case that put in place comparative negligence in Kentucky. Then the justice continues. While changing or extending current precedent should be done with the utmost discretion and deliberation, is an important aspect of our Anglo-American legal system that as society progresses, so should the law. So in that case, the justice was arguing for a change in the law. So the same justice 6 months earlier had dissented and said, unlike some jurisdictions, stare decisis has real meaning in this court, regardless of what the views of the court as now constituted may be as to the soundness of the construction originally given the Constitution. We are of the opinion that the construction should be adhered to under the doctrine of stare decisis. And since it is of the utmost importance that organic law be of certain meaning and fixed interpretation, decisions construing a Constitution should be followed in the absence of strong reasons for changing them. So again, the justice in the prior case was for a change in the law, and the justice in this case was for maintaining the law. So again, as I stated, sometimes it depends on the justice, sometimes it depends on the case. I'll call out the Chief Justice because he's a big guy, he can take it. So he wrote, while stare decisis in this case that he wrote, it was his concurrence in Zuckerman versus Bevan. That I wrote the majority in. It was a 4-3 decision upholding the legislature's right to work decision. So the Chief states, while stare decisis is an important guiding principle, it is not absolute. Stare decisis is the preferred course because it promotes even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. Adhering to precedent is usually the wise policy because in most matters it is more important than the applicable rule of law be settled than it be settled right. So again, there's that quotation coming from Brandeis again. Nevertheless, when governing decisions are unworkable or are badly reasoned, this court has never felt constrained to follow precedent. As an aside, so in the Zuckerman case, he's not arguing that the majority opinion was wrong. He follows the majority opinion because it's a concurrence. What he's arguing is that our jurisprudence governing what constitutes special legislation is a little out of whack, and because the three dissenters had argued that the legislation in question was special legislation, and the 4 of the 7 agreed or decided that it was not. So anyway, the Chief goes on, stare decisis is not an inexorable command, rather it is a principle of policy and not a mechanical formulation of adherence to the latest decision. This is particularly true in constitutional cases because in such cases, correction through legislative action is practically impossible. As an aside to that, I will say that in another case, we looked at the Kentucky Constitution has been amended 7 times since 2000. So the prohibition or the difficulty of amending the federal Constitution in some ways doesn't really apply in Kentucky because, yeah, you got to jump through some hoops. It's a little bit unwieldy. But the Kentucky Constitution gets amended a lot more than the federal Constitution does. So the Chief Justice goes on, considerations in favor of stare decisis are at their acme in cases involving property and contact rights where reliance interests are involved. The opposite is true in cases involving procedural and evidentiary rules. And he also cites Payne versus Tennessee, which I think Professor Morley had quoted as well. So again, the chief says, in the words of this court is not assigned the duty of maintaining the watch as the law ossifies. At times, through proper analysis, sound jurisprudence mandates we refuse to unquestionably follow prior decisions. And then one more, Osborne versus Keeney. The chief quoted a paragraph regarding the value of precedent, but then overruled prior precedents. However, overwhelming evidence existed that 40 other jurisdictions had either rejected or abandoned the same rule that the majority overruled. And finally, Justice Hughes, again, I'm not really calling her out. She says, this is a statutory and not a constitutional case, so stare decisis is even stronger than it is in the constitutional cases to which Justice Brandeis referred. Simply put, in the 40 years since Cooper, the Kentucky legislature could have provided correction if the decision were truly flawed, and it has not done so. So the final thing I'll say is that usually stare decisis seems to be mentioned by dissents. I'd say judges 80% of the time follow the law that's been laid down, and that's following stare decisis. It's when the majority is overruling or is maybe stretching a prior precedence that a dissent or a concurrence is expressed that talks about you're not following stare decisis.
Thank you very much, Justice VanMeter. And we're now going to turn to John Scheller, who's going to explain to us why practitioners are frustrated with the way judges apply stare decisis.
Thank you. I assume since we're in the legislative chamber here, I have immunity. I do not. Sorry, I got it wrong off the bat. Most of us practitioners, of course, aren't going to spend a great deal of time in the U.S. Supreme Court and not really that much time in the Kentucky Supreme Court, although I have had a few cases up there. So what I want to do is drill down a little bit on horizontal stare decisis in the context of the first level appellate court. And mostly I'm going to talk about the Sixth Circuit, but I think a lot of what I'm going to say would also apply to the Kentucky Court of Appeals as well. The courts where most practitioners are going to spend the vast majority of their appellate time. Now, I did a little math just because I was curious about this. And as you all probably know, the Sixth Circuit currently has 28 judges, including all the senior judges, 28 judges. And of course, they sit in 3-member panels. Now, if you go back to, I forgot, maybe it was 10th grade or something, you figured out how to figure out mathematically how many different combinations that is. Well, I couldn't figure it out, actually, but I did find a calculator that could figure it out. And it turns out, believe it or not, there are 3,276 possible combinations of 3-judge panels when you have 28 different judges. Okay, now that doesn't include the fact that the Sixth Circuit has other circuit judges from other circuits sitting by designation from time to time. If you add in all of those people, then the number rises exponentially. The Sixth Circuit also sits with district court judges by designation. And when you add in all of those people, again, it rises exponentially. Tens of thousands of combinations when you add in all those possible judges sitting on the Sixth Circuit panel. Now, so you have to have horizontal stare decisis, right? Or you could have 3,200 different panels going off in all different directions. And horizontal stare decisis in the circuits, including the Sixth, essentially means either by case law or by rule or both, 3-judge panels' decisions are binding on all subsequent panels. Now, I thought it was ironic. I looked up how this originated in the Sixth Circuit, and it wasn't by rule. It's by rule now. I can't remember the number of the rule, but it's in the rules now. But originally, it was a case. Okay? Salmi, I believe is the name of the case. And I thought, well, Salmi must have been an en banc opinion, because how else could the court decide for all of its successor panels that they're bound by what that panel said? Only the en banc court can do that. No, I was wrong. Turns out it's a 3-judge panel. How in the world does one 3-judge panel announce in what, I think it was 76 or 78 or something, that all of the subsequent panels are bound, including by that rule announced in that case, right? The rule that they're bound. I don't know the answer to that question, but I know all the other circuits do it with the exception of one. The Seventh Circuit does not have this rule, but the Seventh Circuit uses a different system that actually may have some merit to it. The Seventh Circuit says a panel is not prohibited from overruling its own precedent, but that if it is going to, it needs to circulate the proposed opinion that would be overruling all the prior precedent to the rest of the judges on the en banc panel. All right? And then if the rest of the judges on the en banc panel say, don't do it, then they don't do it, a majority. Or if they acquiesce in it, then it's done. So there may be some merit to that. But all the other circuits, I think, including the DC Circuit and the Federal Circuit, have this rule, like the Sixth Circuit, that everything is bound. Now, okay, so here you are as a practitioner in front of any given Sixth Circuit panel, and of course, the precedent is against you. And of course, the panel you're in front of can't do anything about it, right? They're bound by the rule that says we're bound by prior opinions. So what is the practitioner going to do? Well, there's some tension there because we have Rule 11, right? We have the appellate equivalent of Rule 11, which is Federal Rule 38, and a subsection of State Rule 73 about the propriety of arguments that you make on appeal. We also have rules of professional conduct that create some tension here. You got Rule 3.1, which says that there has to be meritorious claims and contentions. And you have Rule 3.3 that says there has to be candor toward the tribunal, right? So can a practitioner, consistent with those various rules, advocate to a panel that is bound by the prior precedent that that court ought to overrule the precedent? Isn't it futile? I mean, it ought to be futile. If the court lives by its own rule, then that is a completely futile and arguably improper argument under the four rules I just listed. Rule 11, Rule 38, Rule 3.1, Rule 3.3, right? Okay. Now, I want to give you a cite. Wright versus Spalding. I only have the Lexis cite. It's 2019 U.S. App Lexis 28325. Sixth Circuit, September 19th, 2019. It will be published. I don't have the other two cites yet. It will be published. Judge Thapar wrote the opinion. But what's really, really curious about this opinion is that it was three Kentucky judges, Judge Thapar, Judge Hood, sitting by designation, and Judge Seiler. So you have a senior judge, a district judge, and a regular judge, right? So it's like 10,000 different possible combinations of the three-judge panel, right? Now, what's even more interesting about this opinion is that Judge Thapar writes the majority opinion, and then he writes a concurring opinion to his own opinion. Now, this is pretty interesting. You don't see that every day. Once in a great while, you do. Okay, now it's a habeas case. Now, I'm a civil lawyer, and habeas cases to me are like tax cases. You know, they're just... But what Judge Thapar has to do as a generalist on the court is muddle through decades of opinions from both the Supreme Court and the Sixth Circuit on habeas. And they're all over the place. It takes about a dozen pages just to walk through all the various precedents from the Supreme Court and the Sixth Circuit on this issue to come up with an opinion that Judge Hood and Judge Seiler will sign on to. And of course, they did. And I can't even remember. I think the guy lost in the habeas case. And what was important about the majority opinion was that, the unanimous majority opinion, was that There is an important distinction for purposes of this horizontal stare decisis rule, and that is it only covers holdings, right? Holdings, not dicta. So how do you thread the needle when you have to comply with all these ethical rules, all these Rule 11 type rules, but you know the court was wrong and they messed up, and you really need to advocate for a change? It's dicta, right? Make a good faith argument that that prior opinion was dicta. And then you're not, the panel's not bound. And if you can convince two of them, then you've got it, right? So that's how you do it. Dicta. Of course, I think my colleague down at the end is going to tell us later that, well, you can preserve the argument in the district court where it's futile, and you can preserve the argument in the initial three-judge panel where it's futile, and then you just say, well, but I want to have this overruled en banc, or I want to have this overruled by the Supreme Court. Okay, yeah, in theory, but how many cases do they take en banc? How many cases does the Supreme Court grant cert on? Right? It's statistically impossible. So I think dicta is the answer. Now I want to talk about one other aspect of horizontal stare decisis that I think is intriguing. And practitioners face similar sorts of obstacles in this context. Now think about horizontal stare decisis between the two different court systems, right? Let's say you have a state law claim in federal court on diversity jurisdiction. The federal court's bound by the state court law, right? Same argument, same futility kind of arguments. I can't argue to a federal court to overrule state law. Well, but maybe I can, right? If it's dicta. And conversely, how about the state courts would be bound by the Supreme Court's interpretation of the Constitution? First Amendment, say, Fourth Amendment, Second Amendment. Maybe it's dicta, right? So they keep that in mind, that horizontal stare decisis is not just within the same court system, it can transcend the court systems between the state and federal system. Now, I want to touch a little bit on what the professor was talking about with respect to originalism and stare decisis. And it seems to me that there's one overriding way to distinguish between cases that are vulnerable to being overturned and cases that are not really vulnerable to being overturned, all right? And I think the key to those, the difference is it based in the text? Is it based in the text of the Constitution? It would be extremely difficult, it seems to me, for 5 members of the Supreme Court or 4 members of the Kentucky Supreme Court to overturn precedent that was based in text. If it, on the other hand, is based in the text of an opinion of the court rather than the text of the Constitution, then it's, I wouldn't say whim, but it's essentially whatever that 5-member or 4-member majority thinks at the time, right? And of course, the older the precedent is, the more vulnerable it becomes. And let me just throw out a few of the cases that I think that would illustrate this point. Think about things that are, really, really fundamental to our society, to our system. Marbury versus Madison. It's based in the text, right? You can find in the structure of the Constitution the requirement that the judiciary states what the law is. The right to counsel is based in the text. The words are right there in the Sixth Amendment, right? The Loving versus Virginia, equal protection is solidly based right in the text of the 14th Amendment. Now think of other sort of landmark cases where I search in vain for a textual foundation for the decision. I'm not saying the decision's wrong necessarily. I think most of the time I would suggest that the decisions were rightly decided. But what I'm suggesting is that they are more vulnerable to overruling by a majority of the court because they aren't based in the text, which is a little bit different than originalism. I'm talking about textualism. I think the Miranda was brought up by somebody, and I don't see Miranda in the text of the Constitution, right? You can glean Miranda from the Constitution, what people used to call penumbras, right? But you can't find words that are the foundation for Miranda. How about Roe v. Wade? Right? Earlier, Senator Paul was talking about Griswold. He finds the text in the Ninth Amendment, but it's pretty vague. All right. How about Texas versus Johnson? Remember the Texas versus Johnson case is about flag burning, right? How did flag burning become speech? For purpose, I'm not saying it's a wrong decision. I'm saying, what's the anchor to the text? All right. Now, in the last two terms of the Supreme Court, the Supreme Court has issued 4 decisions overruling precedent. I mean, kind of landmark kind of decisions and precedent. Somebody already mentioned Janus. It was 5-4. It overruled the 1977 decision that was 6-3, right? South Dakota versus Wayfair. This is the sales tax on internet sales. That was also 5-4, overruling a decision from the 80s that was 6-3. Just this past term, there was Franchise Board versus Hyatt. That was about state sovereign immunity. 5-4, overruling a decision that was 6-3. And then finally, Nick versus Township of Scott, which was about the venue for taking cases. 5-4, overruling a 7-1 decision. Now, I didn't just pick those out of thin air. Those were the 4 cases that the court decided in the last 2 terms where they overruled precedent, and every single one of them was 5-4. Now, what's interesting to me, too, is I bet if we all secretly sat down and wrote down who we think are the 5 and who we think are the 4, 98% of us would get it right. And I don't think that's a good thing, personally. But that's how stare decisis is working in our current jurisprudence. A couple of times, justices have talked about stare decisis, principally in dissenting opinions or concurrences, as somebody mentioned earlier. And it was not found in those 4 cases in the majority opinion. So, thank you very much.
Thank you very much. And now, as you mentioned, Cassie Chambers Armstrong will tell us how to get around stare decisis.
Thank you, Judge Thapar. And I want to thank the Federalist Society for having me here today. I have an 11-week-old infant at home, so it's still quite a treat to get out of the house and be able to go through the drive-thru to get a cup of coffee that I didn't brew myself. And it's certainly a treat to be here with you all today. So I'm here today to talk a little bit about my background in impact litigation. That's a term that I'm going to use a lot, so I want to define it from the outset. I use a broad definition of impact litigation. For me, it's just any time that you're using courts or lawsuits to affect some sort of societal change. So it might seem under that definition that impact litigation is necessarily antithetical to stare decisis and precedent. I don't think that it is. I think that there's a role for advocating for changing precedent that is wrong and that is a barrier and causes sort of problems. But sometimes you're arguing to create a precedent where one might not exist and where there might be some ambiguity in the law, and you're arguing for a particular interpretation of the law that you think will lead to some sort of societal change that is good. So I'm going to walk you through a little bit about how I think about impact litigation cases when I, as a practitioner, am thinking about taking on a case that I would consider an impact case. And I think this is a framework that a lot of my colleagues in the impact litigation field use as well. So I'll start off by giving you a little bit of an overview of the type of work I do, because throughout I'm going to refer to sort of particular cases and particular decisions that I've encountered in my time in practice. A lot of my work focuses around informa pauperis law. Informa pauperis is a status that a court can grant someone when they find that they're a poor person. And under Kentucky, there's a statute that basically says if a court finds someone to be a poor person, then that person has the right to access all needful services from the court to defend or maintain an action. And you can see right there, there's some ambiguous terms. What is an action? What does it mean to file or maintain an action? And then the big one, of course, is what is a needful service? That's sort of a vague term and one that doesn't have a sort of common sense definition to it. And so the first question whenever I'm looking at these types of cases, something involving informa pauperis law, and a lot of my work has involved arguing to sort of include more things under the definition of needful services. The first question I ask myself when I'm looking at a case is, does a precedent actually exist on point, and is it really an impediment? And sometimes that is the start and the end of the inquiry. If there is a precedent that is exactly on point in a recent case, a lot of times, impact litigators, you don't want to necessarily start this process that's going to create bad law, that's going to drag your clients through the litigation process. If there is a precedent that is exactly on point and you really believe that it is an impediment to achieving your goals. So one example in the area of poverty law is a case called Spies versus Kentucky Legal Aid. Now, in that case, there was someone who'd been granted informa pauperis status. The court found that they were a poor person, and they were trying to get a divorce. And as part of that divorce process, they had to have a warning order attorney appointed. You all might remember from your federal civil procedure class days that a warning order attorney is someone who affects service when you're having trouble serving people in other ways. And under Kentucky, there's a statute that says that if you have to have a warning order attorney appointed for service, then that person is entitled to compensation for the services that they're providing. So the question in Spies was, you have this person who's been granted informa pauperis status, they're a poor person, do they still have to pay that warning order attorney for the fee? Now, in this case, I think the fee was relatively small. I believe it was something like $150. But there are some cases that I've encountered where warning order attorney fees can run into the thousands of dollars depending on how many hours the warning order attorney spends trying to serve someone and the complexities of any particular case. And the case went all the way up to the Kentucky Supreme Court. There were other issues involved, but for our purposes, this is the only one that's relevant. And what the court did there is they looked and they said, yeah, we have this informa pauperis statute, but we also have this warning order attorney statute. And we find the warning order attorney statute to be more precise than the informa pauperis statute. So we're going to say that that more specific statute trumps the more general one, and the person, even though they have this status, they still have to pay that fee. Of course, there are some constitutional implications for poor people accessing the courts. Basically, the U.S. Supreme Court in a case called Abate versus Connecticut says that the Due Process Clause of the United States Constitution requires that poor people will be allowed to access the courts without paying fees. And the way they got around that was they sort of said, well, in this case, we're not dealing with access to the courts from the outset. We're dealing with access to the courts sort of after the fact. This person was able to have their divorce. They were able to have their case adjudicated. It doesn't violate due process that they have to pay a fee after the fact. It didn't stop them from actually utilizing the court system. So this case is, I think a lot of people in the poverty law community and looking at impact litigation would say, this case, there are a lot of fees out there that we would like to try to challenge. There are a lot of costs that poor people have to pay in our court system. But the logic that was utilized by the Supreme Court in this case is very much on point to what we would be arguing in these types of cases. So a lot of times, if you're looking at a case, there's a precedent, the reasoning that was used in that precedent is exactly the sort of logic that you would be trying to employ. Probably not a good idea to go and risk creating bad law, dragging your clients through a fruitless litigation process. So again, sometimes does a precedent exist and is it an impediment? That's the start and the end of the inquiry. The second question, if you can get past that first question, is if a precedent does exist, how likely are you to succeed in challenging it? Now, just because there isn't a precedent or a case exactly on point, or say there is a precedent on point and you think that it's a good time to take it on, or that perhaps it's vulnerable to challenge, that doesn't necessarily mean that that particular time is the right time to take it on. Some factors that I think a lot of impact litigators look at, you look at things like who is your client? In what particular context is this case shaping up? Sometimes there are organizations that try to take a bunch of different cases all at once. There are these big national organizations that will go into a bunch of different states and try to be bringing cases on the same issue in a lot of different jurisdictions to sort of maximize the chances that they'll get favorable opinions or they'll be litigating on a lot of different fronts. These are all things that you want to think about when you're deciding if it's time to challenge a precedent or not. And just to throw in a little bit of legal realism, you also have to look at who's emboldened in the current environment and who's going to be deciding and what venue you're in and what forum and who's been appointed. These are all things that impact litigators consider whenever you're trying to decide, is this the time to take on a particular precedent? So I talked a little bit about how, given the Spies precedent, a lot of the poverty law litigation is kind of, people are a little hesitant to take it on. There is the example of expungements, however, where these factors have sort of weighed in favor of trying to chip away at some of the fees associated with expungements. So in Kentucky, it used to be that you had to pay $500 to get an expungement. That just changed to $250. And a lot of courts say that that fee is not waivable, that even if you have informa pauperis status, even if you're a poor person, you should still have to pay that expungement filing fee. Expungements are an issue that has a lot of bipartisan support. It's an issue that's very sort of trendy right now. It's being challenged in a lot of different venues. There's a petition for cert before the United States Supreme Court challenging filing fees in expungement cases. And it's a little bit different than the cases I was talking about before because it does involve access to the court system from the outset. It involves a filing fee. If you can't pay the filing fee, you can't initiate an action. And so that's an example of all of these other factors, the current political environment, making it so that there are some cases in Kentucky where impact litigators in the poverty law space are challenging expungement law and trying to sort of chip away at the idea that poor people should have to pay for expungements. An additional thing about expungements that personally, when I'm looking at impact litigation cases, I always like to have sort of a constitutional hook to it. I think if you can say that someone's constitutional rights are being violated, you usually have a much better, stronger argument. And of course, expungements in Kentucky, if you have a felony on your record, you're permanently disenfranchised, you can't vote. And so whenever you're talking about an expungement as a way to remove felonies from people's records, you can sort of tie it into would this violate due process to stop poor people from being able to regain their voting rights? The third question that a lot of impact litigators ask themselves is, if you're going to challenge a precedent, exactly how do you do it? And I think there are really two main approaches that you could take here. There's sort of the practical chip away approach versus the ideological purity approach. And personally, I think that it's really specific to the case, specific to the client, specific to the lawyer, specific to what's going on in sort of the legal setting. An example of this is the case of Bork v. Bashir, which was the same-sex marriage case that Judge Hayburn authored that eventually became part of the cases that went up to the United States Supreme Court. So in that case, Judge Hayburn had applied rational basis scrutiny and found that there was no rational basis for the state to deny same-sex couples the right to marry. Now, some impact litigators with a particular ideological perspective might say, when this case is up on appeal before the Sixth Circuit, we want to reinvent the world from first principles. We want to argue for strict scrutiny. We want to argue for heightened scrutiny. We want to sort of start over and argue from the very first principle about our position. Versus, a more pragmatic approach would be, we have a district court opinion that finds in our favor that is well-reasoned, we should, support and maintain and argue in favor of that position. And so I think that's a question that impact litigators have to decide is how much do you want to be ideologically pure and how much do you want to sort of chip away and be pragmatic in the context as it exists. So I will wrap up to make sure we have plenty of time for questions. Sort of in conclusion, I think impact litigation is an area that recognizes precedent and respects it. I think you have to. You can't just pretend that it doesn't exist. And you certainly have to be candid with the court about when it does exist. You don't want to be caught sort of not citing a precedent and not being honest and forthcoming with the tribunal about what you're trying to do. You lose all credibility. You need to be thoughtful about when and how to challenge precedent. But also, I think most impact litigators say that you shouldn't be afraid to take on precedent whenever it's become a barrier, whenever it's bad precedent, whenever it's causing problems in society. So with that, I will wrap up. Thank you.
Thank you. Questions? Does anyone have a? Yes.
When the courts are looking at overruling something, how much in depth do they look at whether or not it was a 7-0 in Kentucky or a 4-3 in Kentucky or a 9-0 or a 7-2? Because I would think that some precedents are not as strong based on the split of the majority versus dissenting opinions.
Thank you. Justice, you want to?
I'm colorblind, so I can't tell the color on the microphone. We had a case called Parker versus Webster County Coal that had to do with an interpretation of a workers' compensation case. And we had two prior decisions, maybe from 20 years ago, 25 years ago, but there were two that basically said that this workers' compensation statute did not violate equal protection. And so then in the recent case, it was a 4-3, it flipped. I don't recall that issue came up about the strength of the prior precedent, and it was 4-3 prior, and it's 4-3 the other way this time. A funny story about that case, though, is that about a year after I was at an event, and a lawyer came up to me and said, "You all have ruined the workers' comp. You have absolutely ruined workers' comp." And I'm like, what are you talking about? And he said, "I'll show you." And so he got on his phone and he pulled up Parker versus Webster County Coal Company. I'm like, "Oh, you mean the case I was in the dissent on?" So he goes, "Oh, okay, well, all right. Well, maybe not you particularly." So anyway, I think that's a really good question. I just, in the conference, I've been on the Supreme Court for about 3 years, and it hadn't come up. I mean, that hadn't been an issue that's come up. Usually what we're talking about is, I think as Mr. Scheller talked about, whether a precedent was based in the text or based on an interpretation of the text. So, and he talks about whether a case talks about equal protection. Well, equal protection and due process, those are a little bit malleable kind of concepts, right? That you can make the distinction between, well, what's due process, what's equal protection, we can maybe disagree. Versus, say, for example, in the Kentucky Constitution, I think a state rep has to be 24. Well, that's hardwired. There's no discussion about what does it mean to be 24. So I think that's, or what's, the case I gave the example on was the criminal, whether the Commonwealth can appeal a judgment of acquittal. Yeah, I mean, it flat out says the Commonwealth may not appeal the judgment of acquittal. I mean, that's pretty strong. So I think that's what we look at, is I think we look at more at what does the text say.
For our law journal tryout note this summer, we wrote about legislator-led prayer and the circuit split. I can't remember the circuits, but anyways, there was a circuit split on whether legislators should be able to lead prayer.
6th and 4th split
Sixth
en
and
banc.
fourth. Okay. And I know that there was a lot of discussion on stare decisis and tradition and of what we've been doing for a lot of time. Is there any opinion on that? Should we be using tradition as a way to back up our stare decisis arguments? Is that something that is wrong? I'm curious to know what you all think.
So, Professor Morley, I'll turn it to you, and maybe one interesting thing to think about is the debate between Justice Thomas and Justice Scalia and McIntyre. And I think that Justice Scalia incorporates tradition post-enactment, and Justice Thomas, and this is about anonymous speech, and Justice Thomas points to things like the Federalist Papers pre the Constitution being ratified.
So that raises a really interesting question, which again goes back to the interplay between originalism and stare decisis. When you are adopting an originalist interpretation of the Constitution, do you just care about what the original public meaning of the words of the Constitution are, or instead do you take what some scholars have argued is a Madisonian approach of constitutional liquidation, to the extent that there's some uncertainty about either what the meaning of the terms are or how they apply in particular situations? Some justices, some scholars have argued, if we look to historical practice, if we look to what the framers did, if we look to how they understood and applied constitutional provisions, and particularly to the extent this gave rise to either a long-standing or an unbroken historical practice, that by looking to practice, that can help to liquidate the meaning of what would otherwise be potentially indeterminate or potentially abstract constitutional provisions, and essentially create constitutional meaning in effect as a rolling amendment process. So even if the Constitution didn't necessarily have a single fixed determinate meaning the moment it was ratified, as some originalists would argue we're confined to, others would instead say, by looking to that liquidation, by looking to that particularly early practice, unbroken historical practice, that can help to fix the meaning of constitutional provisions and in effect render certain things either constitutional or unconstitutional, even if pure originalism on its own would lead to a different conclusion. With regard to, one final thought to throw out there, with regard to a controversial issue like legislative prayer, where the Supreme Court has already spoken on the issue, and where later Supreme Court rulings would presumably be at least somewhat cabined or somewhat influenced by those earlier pronouncements, an unsettled issue is, can Congress abrogate stare decisis? Particularly when it comes to vertical stare decisis is at least somewhat constitutionally compelled. The notion of you have a Supreme Court presupposes that lower courts will be bound by its rulings as a matter of vertical stare decisis. But horizontal stare decisis, that is a rule the courts have used. It does not appear in the text of the Constitution. Few judges or scholars have argued it is constitutionally mandated. To the extent it is seen as a matter of judicial policy, to the extent it is seen as a default rule, a matter of constitutional common law, could Congress come along and say, either in some subset of cases or in all cases, we want the Supreme Court to do what it thinks the right thing is and not to be bound by horizontal stare decisis, not to come to a different conclusion simply because it already has precedence on legislative prayer or on other issues. And that's a very controversial, a very interesting, I think, and also unsettled issue about where does stare decisis come from? If it's not in the Constitution, then that means it is potentially changeable. It isn't an immutable rule. And just like Congress has ultimate control over the rules that the courts use under the Rules Enabling Act, just like Congress has ultimate authority over the rules of evidence, so too might Congress have ultimate authority over the rules of horizontal stare decisis.
Thank you, Professor. And to keep us on time, we'll wrap up. The liquidation articles, by the way, are by Caleb Nelson and Will Bode, correct? So for anyone that's interested. And the debate, as the professor mentioned, on horizontal stare decisis is between Gary Lawson and McGinnis and Rapaport for the originalist scholars. Okay, thank you all very much. Thank you to this great panel.